But again, it just tells the story of it's the evil and the ugliness of people's hearts these days is everywhere.
This is Frankie Rose's Think Tank. Here's your host, Frankie Rose.
Hey guys, welcome to the Think Tank. So we are going to go over, it's a document from March 23rd, 2023, and it is from the Michigan Court of Appeals. So this document is for both Jennifer and James. So I'll probably just do the one, at least for now. I'm not quite sure when he is going to trial. I don't even think there's a date set yet. So for now, this is basically for Jennifer Lynn Crumbley, defendant. Okay, so I've gone through and highlighted a lot of these different things. So I will, for the most part, stick to those, but I will fill it in just to make sure we've got all the information related to this instead of filling your heads and my head full of the stuff in between that just is not quite as important. So defendants James and Jennifer Crumbley are the parents of EC Ethan Crumbley, who deleted 4 fellow students and injured many others at the Oxford High School on November 30th, 2021. Now, he pled guilty to 4 charges of first degree. In these proceedings, the state has charged defendant with 4 counts of involuntary manslaughter related to those same passings. So the background preliminary exam evidence, Ethan, who was 25 years old at the time, took a weapon into his school and deleted 4 children. Early 2021, Ethan Crumbley began verbalizing situations he was experiencing that reflected instability of his mental health. Sending messages in close temporal proximity, describing his self-described paranoia that someone was in the house with him. There's someone in the house, I think. Someone walked into the bedroom and flushed the toilet and left the light on. And I thought it was you. But when I came out, there was no one home. There's no one in the house. Though, and my dude, my door slammed about 10 minutes later. When Jennifer had not responded, Ethan sent 2 more text messages saying, maybe it's just my paranoia, and asking, but when are you going to be home? Jennifer did not respond until the next morning. According to the defendant's cell phone records, neither defendant called Ethan that night. Ethan sent additional text messages to Jennifer, this time reflecting his belief that a demon was in the house and that it was throwing objects inside the house and that he had taken pictures of it. Okay, the house is now haunted. Some weird shite just happened and now I'm scared. I got some videos and pictures of the demon. It's throwing bowls. I'm not joking. It's effed up the kitchen, and I'm just going to be an outsider for a while. When Jennifer did not respond quickly enough, Ethan wrote, can you at least text me back? And her cell phone contained photographs showing she was taking pictures of James and herself riding horses at the time these messages were sent. Just disgusting. So let's see here. All I know is he needs to eat. Okay. Approximately 2 days later, Jennifer messaged James about how Ethan was doing, and James responded that he woke up looking like he had way too much to drink last night, complaining about a headache. Jennifer was not surprised by Ethan's state, telling James, well, Ethan was really worked up and out of control, so I can see why. Jennifer sent another message. All I know is that he needs to eat, go to work, and work hard and not complain. And he gets his stuff back. When James relayed something Ethan apparently said that morning, he said, let me ask you a question. Why am I in your guys' room? LOL. Jennifer responded, oh my God. And James said, I totally thought you were giving him Xanax last night. Jennifer stated she had given him melatonin, a natural sleep aid. EC continued to experience hallucination type events. For 2 days later, on March 20th, Ethan sent Jennifer several text messages in quick succession. I cleaned up the clothes and they started flying off the shelf. This stuff only happens when I'm home alone, and I picked the clothes back up though. Once Jennifer was at the barn when those messages were sent and she did not respond. So she was there, able to get messages and not responding to her kid. Just after midnight on April 5th, 2021, Ethan sent text messages telling his friend that he was going to ask his parents to go to the doctor tomorrow or Tuesday again. This time I'm going to tell them about the voices, and I only told them about the people I saw. Among other things, Ethan told his friend that he had researched his symptoms and believed he was having a mental breakdown. True to his word, Ethan informed his friend that he had asked his parents for medical help, but that James refused the request, instead, giving him some pills and telling him to suck it up. Oh my God. This is probably part of the reason that they're being held accountable for some of his actions. Unreal. So Jennifer, according to Ethan, laughed at their request because she did not believe he had any mental health issues, but was instead using substances that made Ethan feel like shite, such that he considered calling 911 so someone would take him to the hospital where he can get some help. Ethan decided not to do so, he said, because defendants would be angry with him. Conversations about wanting weapons and making plans to buy them. For instance, 3 months before this happened, Ethan sent his friend an 11-second video showing him loading a magazine into a .22 Caltech weapon registered to James. Ethan's friend responded, nice, and wrote, now pull the, yeah. Okay, just kidding, joke, 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 joke. Ethan responded that my dad left it out, so I thought, why not? Lol. And I know weapon safety, so it's no problem. Ethan then said, now it's time to bang up the school. And then he said, joke, 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 joke. By October 2021, several months into the first message, in evidence on the topic of Ethan and his friend were still discussed. Ethan believed that he was having a mental breakdown. Defendants' text conversations at the same period showed no indication that they considered finding some help for Ethan. Jennifer did not speak about Ethan often, but when she did, she described him as weird and that he had no friends. Oh, way to go, Mama. Way to go. I see an award coming your way. Ethan also kept a journal. The journal referenced his friend, contained a drawing of a headless bird, depicted a demon, and discussed various issues of Ethan's life. 21 pages of written material had reference to plans to commit a school chooting. In one entry, for example, Ethan wrote, I will cause the biggest school chooting in Michigan's history, and I will delete everyone I effing see. Ethan also described a specific plan, explaining the first victim was to be a pretty girl with a future so she can suffer like him. That same page contained a drawing of a girl being injured in the back of her head. I have fully mentally lost it. After years of fighting my dark side, my parents won't listen to me about help or a therapist, and I have zero help for my mental problems. And it's causing me to choot up the effing school. November 26th, James and Ethan went to a shop because James wanted to purchase a 9mm Sig Sauer. James signed indicated that purchasing a weapon for someone else was illegal. Once a background check was done, James was cleared, and they were given that weapon containing a cable lock, a trigger lock, and an ATF Youth Notice Act pamphlet and extra magazines of ammo. Later that day, Ethan posted 2 photographs and a video on his Instagram account. Both photographs were of the SIG, and the video showed Ethan holding it. Instagram post stated, just got my new beauty today. SIG 9mm. Ask any questions, I will answer. And the next day, Jennifer took him to a shooting range. Later that day, Ethan posted on his Instagram account a photograph of the target with holes through it and with a caption stating, took my SIG out to the range today. Mum and Son Day, testing out his new Xmas present, is something that she put on her Instagram. In the early morning hours of Monday, November 29th, Jennifer performed an internet search on treatment options for clinical depressions. While in class, a teacher saw Ethan looking at weapon ammunition on his cell phone. Ethan explained he was looking at the ammunition because was shooting was a hobby, and he had just gone to the range with Jennifer and wanted to look up different bulls. A school official attempted to contact Jennifer about the incident, leaving a voicemail explaining that weapons may be a hobby and there's nothing wrong with that, but that it was improper classroom activity. The official did not request Jennifer to call back, and she did not do so. So Jennifer wrote Ethan, seriously looking up those in school? And he was like, oh yeah, I already went to the office for that. It was in the first hour. And all I did was look up certain caliber at the end of class because I was curious. Jennifer wrote back that Ethan was not in trouble. Jennifer asked, did you at least show him a pic of your new weapon? No, I didn't show him the pic. My God, I have this cartridge in my room that I didn't know what kind it was. It was a 22. So at the end of the first hour, I just looked up different types of 22 bulls. Okay, Jennifer responded by writing, LOL, I'm not mad. You have to learn not to get caught. Oh, good advice, Mama. According to the co-worker, Jennifer did not seem concerned about the message. On the morning of November 30th, Jennifer went to work. James went to the barn to check on a sick horse, and Ethan went to school. In Ethan's backpack was the SIG and his journal. The last entry in Ethan's journal was written the day before, where he noted that he had this weapon and the ammo, specifically mentioned 9mm SIG, and proclaimed the school shoot would be the next day. Ethan also wrote "Forgive me" in big bold letters. So there is this drawing. I'm going to see if I can bump it up for you. So let's see here. This was in one of his books. Looks like it was possibly math class. Ethan Crumbley, number 1, November 30th, 2021 at 8:59. So there's this. And it says, "The thoughts won't stop. Help me." And then you've got someone here, looks like with a couple injuries, lying on the ground. Not pleasant. My life is useless. The world is DEA Day. EC scribbled out the weapon, which closely resembled the SIG. The person with DNA coming out of him from holes, and the phrase says, "Help me, my life is useless. The world is DEAD. Harmless act. We're all friends here. OHS rocks." And video game, this is modified worksheet, provide a more complete picture on how Ethan tried to cover up what he had initially wrote and drew. So yeah, here's another one where he started scribbling stuff out. Video game, this is "I love my life so much." Harmless act. We're all friends here. The thoughts won't stop. Scribbled out "help me." Scribbled out the weapon and that diagram. And got rid of this caption here. Yeah. Video game, this is. Hopkins then asked Ethan about a math worksheet, and Ethan said that he was drawing about a video game. After Hopkins asked Ethan what the statement that "my life is useless," Ethan's demeanor changed, according to Hopkins. Ethan became sad and started discussing his various troubles in life, specifically mentioning that his friend had moved away, difficulty dealing with restrictions put in place to address COVID-19, and his dog and grandparents passing. Ethan also mentioned that he argued with his parents the night before regarding his grades. Noting a concern about Ethan's mental health and particularly unaliving ideations, Hopkins performed a risk assessment related to Ethan. Hopkins then left a voicemail message for Jennifer and James to call, who also did not. Jesus. Soon after the phone call, Jennifer attempted to call James via Facebook Messenger, stating at 9:30 a.m., "Call now, emergency." Jennifer attached both math sheets, and James responded about 9:44 a.m., saying, "My God, WTF." Jennifer and James spoke on their cell phones for about 7 minutes before arriving at the school. Let's see here. Hopkins informed defendants about a video Ethan had been watching during his first hour in class. He had already sent Jennifer both versions of the math sheet and told the defendants that he was concerned about Ethan's mental health, provided them with a mental health resources, and recommended they immediately take Ethan to a doctor or therapist that day. Hopkins insisted that Ethan get medical attention with 48 hours. The decision was made for Ethan to remain at school. Hopkins believed it was good that Ethan would not be alone, considering the concerns about deleting ideations. Ideations. So what do you think so far? I think that this is not looking good for either one of the parents. They had lots of time to know that he was not doing his best mentally. So during the 15-minute meeting, Jennifer did not speak to Ethan. James, on the other hand, expressed to Ethan that he had people with whom he could talk, including defendants, and encouraged Ethan to write in his journal. Jennifer abruptly asked if the meeting was done, and Hopkins checked with EJAC before everyone left. On their way out, neither defendant hugged or said goodbye to Ethan. Hopkins, though, told Ethan, "I just want you to know I care about you," because he did not believe Ethan was getting parental support. Hopkins doubted whether defendants planned to get Ethan help, so he planned to meet with Ethan the next morning to see how he was doing. Neither EJAC, Hopkins, nor the defendants asked to look inside of Ethan's backpack, which contained his journal and the SIG. Surveillance footage shows the defendant leaving Oxford High School at about 10:54 a.m. and driving out of the parking lot at 10:56. 2 minutes later, Jennifer contacted Pennock to discuss a horse riding lesson for that evening. Pennock testified she was alarmed by the drawings and was aware that the Crumbleys owned weapons. At 12:21, Jennifer sent a text message to Ethan asking if he was okay. He responded he had just finished lunch. Jennifer then wrote, "You know you can talk to us and we won't judge," to which Ethan responded at 12:42, "I know, thank you. I'm sorry for that. I love you." Fewer than 10 minutes after sending that message, Ethan went into the bathroom with his backpack and came out with the SIG and committed the M's, while also injuring 6 other students and 1 teacher. By 12:58, the shooting was over. Oxford High School sent out alerts to the parents. An active shooter was within the school. Jennifer received the information while at work and started screaming. Upon receiving the alert, James drove home and unsuccessfully searched for the SIG and ammo. At 1:18 p.m., Jennifer responded to Ethan's last text message by writing, "I love you too," and asking, "Are you okay?" 4 minutes later, Jennifer told Ethan, "Don't do it." James apparently informed her that the weapon and ammo was gone because she sent the following text message to a coworker at 1:23 p.m. "The weapon is gone, and so are the ammo." Jennifer then called James, and while sounding frantic that she was to get to the school, and expressed concern that Ethan was going to unalive himself and that Ethan must be the attacker. At 1:34 p.m., James called 911 and told the operator his son went to Oxford High School and that his weapon and ammo were missing from his home. On the day of the shooting, police executed, Police executed a search warrant for defendant's home. In the defendant's bedroom, Detective Adam Stoyak found a weapon case and the SIG open on the bed next to an empty box of 9mm ammo, and locked the safe in a locked weapon safe in a dresser drawer of the defendant's room. The safe had a 3-digit combination lock, which was set at 000. and contains James' other 2 weapons. All of the weapon locks found in the house were still in their original packaging. Detective Stoic did not find any broken locks or a lock with which someone had tampered. Sergeant Matthew Peschke also participated in executing the search warrants and searched Ethan's room. According to Sergeant Peschke, the paper targets from the range were tacked to the walls. Fired casings and an array of folding, a notebook containing detailed drawings of weapons, and the feces of a small animal were on top of the nightstand. What the hell? Felony complaints against defendants were issued soon after their arrest, both of which allege the defendants' grossly negligent conduct caused the passing of the 4 victims by storing his or her firearm and its ammunition so as to allow access to the firearm and ammunition by his or her minor child, or the grossly negligent fail to perform the following legal duty, to wit: failure to exercise reasonable care to control his or her minor child, to prevent him from intentionally harming others or from conducting himself so as to create an unreasonable risk of bodily harm to others, knowing that he or she has the ability to control his or her child and knowing of the necessity and opportunity to do so. So they're basically saying that leaving this around, knowing that his mental health was in the shape that it was, that having this in any area that he might have access to was just not a great idea. It was putting him and others in jeopardy. In this case, after hearing extensive testimony, as well as evidence, and reviewing and viewing extensive exhibits, the court finds that the passing of the 4 victims could have been avoided if James and Jennifer Crumbley exercised ordinary care and diligence in the care of their son. Specifically, the court finds that the prosecutor has shown by a probable cause standard that 1, the son Ethan presented a danger to the community, and number 2, that the danger was apparent to an ordinary mind. Number 3, that the defendants James and Jennifer Crumbley neglected to diligently address and or divert the danger. And number 4, that the danger resulted in the passing of 4 young children at Oxford High School. There was extensive testimony that Ethan Crumbley was certainly a troubled young man, and the defendants had knowledge of the situation, but they purchased a weapon which he believed was his and he was free to use. Therefore, the court is binding the defendants over as charged. Finding probable cause existed to believe defendants committed involuntary M. I'm having a hard time catching my breath. You hear me sniffing and gasping over here? So the court concludes that sufficient evidence has been presented to allow a reasonable juror to find factual causation and allow a reasonable juror to conclude that the passing of the victims was a direct and natural result of the defendant's gross negligence. What do you guys think of that? The court further concludes that the criminal misconduct of the defendant's son was an intervening cause, but that a reasonable juror can conclude that his actions were reasonably foreseeable. A reasonable juror could conclude that the action of the defense's son was a related link in the causal chain. Causation is, of course, an element of involuntary M. Nevertheless, in the criminal law context, the term cause has acquired the unique technical meaning. Specifically, the term and concept have two parts: factual causation and proximate causation. Factual causation exists if a finder of fact determines that. Professor Dressler makes the point that despite such terms and phrases as superseding, intervening cause, direct cause, and remote cause, there is no mechanical way to determine whether a defendant's actions or inactions caused the victim's harm. Although some scholars believe that causation is a metaphysical concept, it appears realistic to say that the courts and juries don't discover the proximate cause of harm, they select it. But for the defendant's conduct, the result would not have happened. Concerns arise regarding whether the defendant's conduct was the proximate or legal cause of the decedent's passing, when the passing is so remote from the defendant's conduct that it would be unjust to permit conviction. Well, if they hadn't done that, he wouldn't have been able to bring that weapon to school. So I think I am going to have to agree with the paperwork at this point, that had he not been purchased that, again, this wouldn't have happened. Okay. Importantly, under the criminal law, there can be more than one cause of harm, as a defendant's acts need only be a contributory cause of what was substantial factor in producing the harm. In assessing criminal liability for some harm, it is not necessary that the party convicted of the crime be the sole cause of that harm, only that he be a contributory cause that was a substantial factor in producing the harm. The criminal law does not require that there be but one proximate cause of harm. Quite on the contrary, all acts that proximately cause the harm were recognized by the law. For a defendant's misconduct to be regarded as a proximate cause, the victim's injuries must be a direct and natural result of the defendant's actions. Sometimes, as in this case, when there may be more than one potential cause of harm to the victim, it is necessary to examine whether there was an intervening cause that superseded the defendant's conduct, such as the causal link between the defendant's conduct and the victim's injury was broken. If the finder of fact determines that an intervening cause supersedes an injury, a defendant's conduct, such as the causal link between the defendant's conduct and the victim's, whereas an intervening cause supersedes the defendant's conduct, is a question of reasonable foreseeability. Ordinary negligence is considered reasonably foreseeable, and it has thus not a superseding cause that would sever proximate causation. On the other hand, an act of God, or the gross negligence or intentional misconduct by the victim or a third party will generally be considered a superseding case. Nevertheless, the linchpin in this superseding cause analysis is whether the intervening cause was foreseeable. Then the defendant's conduct will be considered an appropriate cause. If, however, the intervening act by the victim or a third party was not reasonably foreseeable, example, gross negligence or intentional misconduct, the causal link is severed and the defendant's conduct is not regarded as proximate cause of the victim's surgery or death. The quick dispatch with any argument that factual causation did not exist. Factual causation is relatively easy to establish. The record squarely reports that but for defendant's acts and omissions, Ethan would not have deleted the victims that day. On the basis of the evidence presented at the preliminary exam, a reasonable fact finder could conclude that Ethan would not have been able to delete 4 students but for the defendant's decision to purchase their mentally disturbed son a weapon. Their failure to properly secure it, and most importantly, the refusal to remove Ethan from school when he made overt threats to hurt other people. But for defendant's informed decision to leave Ethan at that school, these deletings would not have occurred that day. Ethan pled guilty to 4 counts of first-degree premeditated M. While there's no dispute during the trial court proceedings that Ethan's actions were intentional, his guilty pleas to first-degree premeditated M cement that fact. But Ethan's intentional misconduct and intervening cause the victim's injury was broken. Such a causal link between the defendant's conduct and the victim's injury was broken, and proximate cause is lacking, and criminal liability cannot be imposed. Mouthfuls. There's a lot in here. So, do you think, I personally think that they knew that Ethan was mentally ill. He gave every indication of asking for some kind of help that never came. I'm not quite sure if that was due to money, or I'm not quite sure why they were not getting him in to talk to somebody before this was able to happen, because they obviously had the signs. The signs are there. Even when articulating the general rule, the intentional misconduct on the part of the victim is considered sufficient to break the causal chain between the defendant and victim. The court notes this is so only because the intentional misconduct is not reasonably foreseeable. Hence, Ethan's intentional misconduct did not, as a matter of law, supersede defendant's acts, being a cause of the victim's passing, as his acts will only supersede defendant's acts if his intentional acts were not reasonably foreseeable, which of course is generally the case. Yeah, this kid gave off lots of warning signs. Even his friends were saying how weird he was. And I can't even say like friends, or are they acquaintances, because he kept to himself a lot. Turning now to the district court's proximate cause determination, the relevant facts revealed that prior to arriving at the school on November 30th, 2021, defendants were aware that EC had been repeatedly experiencing significant episodes of hallucinations or extreme paranoia. EC was dressed in a was distressed. Ethan was in a distressed mental state because of the loss of his grandparents and family dog and the departure of his best friend. Ethan himself realized his poor mental state such that he requested defendants to help him obtain medical assistance. Despite defendants' knowledge of Ethan's mental state, they purchased him a weapon which was readily accessible to Ethan. On November 29th, the day before this happened, Ethan was researching bulls while in school, and during the first hour of class on November 30th, Ethan watched a video involving a shooting and during second hour drew pictures of a bullet, a gun resembling the SIG, a person spilling DNA from the holes, and wrote, "Red DNA everywhere. The thoughts won't stop. Help me. My life is useless and the world is unalive." Defendants were also represented by the significant modifications Ethan made to that worksheet. He clearly intended to portray a different, happier message than about the school and himself. Oh my, I need hydration. I got up this morning and I thought it said 4:05. So, okay. I set up my computer, made coffee, set this all up, sat down, and it was just after 1 a.m. So I'm going to do this for you. And then I might stretch out for a little bit and see if I can look for 4 a.m. instead. Mind you, it's now like 2:55. So there is that. So despite their knowledge of those circumstances, or of all these circumstances, when given the option to help Ethan and take him out of school, defendants did nothing. They did not, contrary to the recommendations of Hopkins, take Ethan home and get him immediate mental health, nor when they decided to leave him at the school. Did they tell the school officials about Ethan's history of mental illness or explain to them that Ethan had access to a weapon, similar to the one he drew on the math worksheets? Defendants neither asked Ethan if he had the weapon with him, nor did they look in his backpack. And when they left the school, defendants did not go home and ensure that Ethan did not take a weapon. Given all those facts, it was not an abuse. It was not an abuse of discretion. My eyes are fogging over. To conclude that there was probable cause to believe that a juror could conclude that reasonably foreseeable outcome of the defendant's alleged gross negligence with Ethan committing the shooting that day. One of the few reasonably foreseeable outcomes of failing to secure the platform that was gifted to EC, that was that it would be accessible to EC, and that in his mental deteriorating condition, he might use it in unlawful ways. In light of those foreseeable events, when presented with what he had just drawn and written and viewed that morning, a reasonable juror would conclude that it was foreseeable that Ethan possessed his recently gifted weapon and intended to use it that day. As a result, a reasonable juror could not conclude that Ethan's intervening acts were not a superseding cause of the passings. Okay, let's see. I'm struggling here. Keep my eyes peeled. Okay, but here, as we've explained, the evidence showed the opposite. Defendants' actions and inactions were So we're very much intertwined with Ethan's actions, with the intervening cause. This connection exists not simply because of the parent-child relationship, but also because of the facts showing defendants were actively involved in Ethan's mental state remaining untreated, and they provided him with the weapon used to delete those 4 kids. And they refused to remove him from the situation that led directly to these shootings. In this circumstance, a reasonable juror could conclude the defendant's conduct increased conclude that the defendant's conduct increased the foreseeable risk of a particular harm occurring, though a second actor, and that what Ethan did at Oxford High School that day was foreseeable. Do you think it was foreseeable? I do. I mean, maybe not thinking your kid's going to go there and like shoot up the school. No, but would I be worried about self-harm? I would. So that would just be a no-go. I don't quite understand the thinking behind this, but I don't know. I don't know these people. And I certainly was not there. So finally, we share defendant's concern about the potential for this decision to be applied into the future of parents whose situation vis-a-vis their child's intentional conduct is not as closely tied together, or that warning signs and evidence were not substantial as they are here. But those concerns are significantly diminished by several well-established principles. First, the principle that grossly negligent or intentional acts are generally superseding causes that remains intact. We simply hold on with these unique facts, and in this procedural posture and applicable standard of review, this case falls outside the general rule regarding intentional acts because Ethan Crumbley's acts were based solely on acts were reasonably foreseeable, and that is the ultimate test that must be applied. Second, our decision is based solely on the recorded evidence and the actions and inactions taken by the defendants, despite the unique troubling facts of which they were fully aware. And this point is important, as although the judiciary typically recognizes that a decision's precedent is limited by the facts at issue, it is particularly true when the court expresses the limitation. Third, our decision is premised upon a deferential standard of review and is based only upon the record established at the preliminary exam, where the jury actually finds the causation has been proven after a full trial, where the record will almost surely be more expansive, including evidence produced by defendants in an issue separate from the video we received today. From an issue separate from what we decide today. We acknowledge defendants' argument that no parent should reasonably foresee their child committing a mass incident. But these issues are based on the fact that is reasonably foreseeable under an objective standard. And these criminal defendants were presented with on November 30th, 2021, provided the heightened set of warnings that could have led the jury to find causation. Additionally, with respect to the foreseeability, more relevant than the number of people shot is the foreseeability that Ethan would shoot someone that day. The district court did not abuse its discretion in determining Ethan's decision to delete 4 classmates. It was not superseding cause because it was foreseeable based on the objective standard of reasonableness. Chris M. Murray, Michael J. Riordan, Christopher P. Yates. So that is the document. Pretty interesting, isn't it? Like I said, I only put in the stuff that was relevant. I didn't put in all of the legal examples and what have you. Just put in the information we needed to know. So I won't keep you guys. I appreciate you being here with me, and I will see you guys in the next one. Bye.